On February 19, 2026, in the 34th Judicial District Court of El Paso County, Texas, Judge Tines Gonzalez presided over a petition to establish the parent-child relationship between Donald Christopher Hicks and Alberta Smith regarding their minor son Giovanni. Both parties appeared pro se, representing themselves without attorneys to address custody, child support, possession schedules, and whether geographic restrictions should apply to the child's residence. This family law proceeding illustrates how Texas courts handle contested conservatorship matters when parents cannot afford or choose not to retain legal counsel.
Okay. And what are those concerns?
Honestly, it's just we've had previous tension, so it's just to keep a stable environment for myself and my child. It's not to create conflict or anything, but simply to maintain appropriate boundaries and privacy, just due to the tension in the past.
And so when you say tension, can you explain to the court what that means for you, or what does that look like?
The aggression from the relationship that I was in. So it's just that, or the current relationship that I'm in. It can cause tension between the now boyfriend that I have and the father of Gio. So I'd rather my location not be disclosed so that there is no tension and everything remains stable.
Mr. Hicks, may you state your name
Yes.
for the record?
Donald Christopher Hicks. Correct.
February of 2020, some temporary orders, correct?
Correct.
Okay. To be Miss Smith was given some, including the right to make medical decisions, correct?
Correct.
Are you asking the court that you and Ms. Smith be allowed to share in that decision making and come to an agreement and be put in place for you and Ms. Smith?
I'm asking the court that we share all.
Okay. As far as educational, medical, and psychological, are you asking that you and Ms. Smith share those duties? Okay. And all. Okay. And so you heard the testimony of Ms. Smith, correct? Okay. You San Antonio?
Yes.
Okay.
Mr. Hicks testified that he seeks shared rights and duties in all areas, educational, medical, and psychological, rather than the arrangement in the temporary order where Ms. Smith held certain exclusive rights. He confirmed his understanding of her planned relocation to San Antonio. Texas Family Code, Section 153.071 establishes that unless limited by court order, a parent appointed as conservator has certain rights regarding the child, including the right to receive information from the other conservator about the child's health, education, and welfare. However, Section 153.132 specifies that courts may grant exclusive rights to one conservator, including the exclusive right to make decisions about the child's education and the right to consent to medical treatment. The 2005 amendments to the Family Code, following the Texas Supreme Court's decision in re JWT 872 SW2 D189, 1994, clarified that joint managing conservatorship does not require equal or nearly equal periods of physical possession, nor does it preclude allocating exclusive decision-making authority to one parent. Mr. Hicks's request for fully shared rights and duties conflicts with the temporary order's allocation and with Ms. Smith's apparent willingness to maintain some exclusive authority. The court must determine whether the cooperative co-parenting relationship or lack thereof supports joint decision-making, or whether exclusive allocation would reduce conflict. Under 53.134b2, the court must consider whether the appointment of joint managing conservators would significantly impair the child's physical health or emotional development, a standard that looks to the parent's ability to cooperate rather than any fault-based analysis. The allocation of decision-making rights often becomes the most contentious issue in joint managing conservatorship cases, even when both parents agree to share physical possession. Courts increasingly recognize that forcing joint decisions between high-conflict parents can harm children more than granting one parent clear authority. Mr. Hicks's blanket request for all shared rights, without addressing the practical mechanisms for resolving disagreements, may reflect either genuine commitment to co-parenting or a strategic position to maximize his legal status. The court's resolution will significantly impact how Giovanni's medical and educational needs are addressed going forward.
In the event that you all are close, possession order.
Correct.
Okay. And a standard possession order.
Friday to Monday. Friday being Friday, Monday morning, every other week.
And how far is the drive from where you currently are to San Antonio?
Location to the heart of San Antonio would be about 50 minutes to an hour.
Okay, and you're willing to exercise your possession?
So it would, I would ask that.
Okay. When did you and Miss
October of 23, of 22.
Did you provide any financial support to Miss Smith after she left the home?
Yes, not only to her for personally for whatever needs she may have needed at the time.
Provided to Miss Smith. Did you make those payments on the schedule?
No. So the only scheduled payment that we've had to date would be his daycare. And I've paid that since I've been allowed to pay it. I would say December of 24. There were increments in between prior to that, but it was never consistent up until December of 24.
Okay. And how were you making those payments?
I would either send it to my card and pay it. Prior, she would use my card more so prior to that December, but after that December of 2020, no ma'am.
Where do you work?
Okay. Mr. Hicks testified that he provided inconsistent financial support to Ms. Smith from their separation in October 2022 until December 2024, when he began making regular daycare payments. He acknowledged no formal schedule governed these earlier payments. Texas Family Code SPLESH 154.009 authorizes courts to order retroactive child support when no previous order existed, limited to 4 years preceding the filing of the petition, unless the court finds that the obligor knew or should have known of the child's existence and sought to avoid establishment of support. Under SPLESH 154.131, retroactive support is calculated using the child support guidelines in effect during each relevant time period, applied to the obligor's net resources during that time. The 2013 amendments to Section 154.009, codifying the Texas Supreme Court's holding in re AR 280 SW 3D 424, 2009, clarified that courts must consider whether the obligee attempted to inform the obligor of the probable parentage and whether the obligor acknowledged parentage when determining whether to award retroactive support and for what period. Mr. Hicks's admission of inconsistent payments creates significant exposure for retroactive child support. The state's request for $31,200 from May 2022 to January 2026, reduced by $15,000 credit for informal payments, depends on establishing his income during each period. His testimony about income, initially $300 sent every 2 weeks and $2,000 from other sources, provides the basis for guideline calculation under Section 154.125, which imputes income based on historical earnings when current circumstances do not reflect earning capacity. The court must reconcile his claim of higher unproven payments against Ms. Smith's testimony that he provided no support after the birth. Retroactive child support disputes often devolve into he said, she said credibility contests where documentary evidence is scarce. Here, both parties' self-representation amplifies the risk of error. Mr. Hicks may not understand that his admission of inconsistent payments undermines his defense, while Ms. Smith's blanket denial of any support may be impeached by his testimony about daycare payments. The court's calculation method, including whether to credit unverified cash payments, will significantly affect the judgment amount and illustrates why formal child support orders protect both parties by establishing clear obligations from inception.
And how often are you paid there?
Every other Friday.
How much are those checks?
They are moving every other Friday. Yes.
And what other income do you have? In your temporary orders, you were on a child support amount of $650, correct?
Correct.
Payments through the state disbursement unit.
No. So the first one I did, but out of my check.
Did you see the exhibit that I was hearing started?
Briefly, yes.
Okay. And in that exhibit of it
That
31 cents.
No.
Okay. So your first payment through the state disbursement unit, how did you make that payment?
I made it online. The entire $650. That was on.
Pass on this judge. The state arrested closed judge requesting that the court appoint Ms. Smith and Mr. Hicks as joint managing conservators, and that the court make rulings on the allocation of rights and duties pursuant to Texas Family Code 1, specifically giving Ms. Smith the exclusive right to determine the child's residence, the right to receive child support, making educational, psychological, and medical by agreement with educational and professionals being a tiebreaker in the event that the parties cannot agree in their decision making. Make rulings based on a non-disclosure based off the testimony before give Mr. Hicks an expanded standard possession order in the event that Ms. Smith is moving closer in, and he is set $182 with obligations beginning take a retroactive amount of $31,200. However, giving him credit for the $15,000 that he testified to, giving Ms. Smith, and that is from the data separation, or about May 2022, and the January 30th setting that fee paid 6 and court called to
So I have a few questions, Ms. House. How did you calculate?
current is going to be based off the $1,346 biweekly, including his amount of with a gross monthly of
His testimony was 1,300 and then 2,000. I didn't
Yes.
see any evidence of anything other than that.
so 1,346 biweekly. There,
No, you've already rest and closed.
yes, ma'am.
Okay, 100 every 2 weeks and 2,000. So what was that amount?
1,000.
And the adjusted amount?
The adjusted
And how did you calculate retroactive child support?
So active child support was calculated using the same adjusted monthly net with support at $887 since the date of separation beginning.
Okay, so I didn't hear any testimony that Mr. Hicks earned any of the amounts to justify that amount for 2020.
The state rested its case requesting specific rulings on conservatorship, rights allocation, geographic restriction, possession, and child support, including retroactive amounts. Judge Gonzalez then questioned the state's attorney about the mathematical basis for the support calculations, probing whether the evidence supported the requested figures. Under Texas Family Code FOL 4.125, child support is calculated as a percentage of the obligor's net resources, defined in SFOL Warn 1154.062 to include wage and salary income, self-employment income, and various other compensation sources, minus specific deductions for taxes and health insurance. The statute mandates application of the guidelines presumptively unless the court finds that application would be unjust or inappropriate under the circumstances. Texas Rule of Civil Procedure 166A requires that summary judgments, and by analogy, requests for affirmative relief in bench trials be supported by evidence that would be admissible at trial. The court's sua sponte examination of the state's calculation methodology reflects its duty under Section 154.122 to ensure that support orders are in the best interest of the child and based on accurate financial information. Judge Gonzalez's questioning exposes a critical gap. The state's attorney appears to have calculated support based on assumptions not fully supported by Mr. Hicks's testimony. His $1,300 every 2 weeks and $2,000 from other sources does not clearly annualize to the state's proposed figures, and the attorney's inability to articulate the adjusted amount after resting her case undermines the request. This judicial intervention illustrates the court's responsibility to protect even unrepresented parties from support orders based on speculative mathematics, particularly when the obligor's pro se status means no opposing counsel will challenge the calculation. Child support calculations have profound long-term consequences. Arrearages accrue interest at 6% annually under Section 157.265, and enforcement mechanisms include license suspension and incarceration. Courts must ensure that the evidentiary foundation for support orders is solid, not merely unchallenged. Here, the judge's skepticism about the state's math models, the careful scrutiny that protects the integrity of the child support system, and prevents future litigation over erroneous orders.
2023, up until the temporary orders. So based on
Page
anything else you would like to address the court before I make my rulings?
I think that the 15,000 that he had mentioned, forgiving me since Gio was born. I also would like to go back and refresh my memory a little bit, because I remember in our last court hearing, the amount that he made was higher than that. Now I don't know his what he's making now current to date, but is that going to affect the child support just due to his our son's financial needs as far as daycare is concerned?
I can only make my ruling based upon the evidence that I hear, and so you've heard what I've heard.
Mm-hmm.
And what I've seen. That's all I can base what my rulings will be.
Yes, Your Honor.
Now, if there's other evidence out there that wasn't presented to the court, everyone has a right to file a motion for new trial or appeal my decision if you wish to do so. An appeal would be in the form of a de novo appeal. You have 3 days to file a de novo appeal to the district court. A motion.
Yes, Your Honor.
Okay.
15. Sorry, Your Honor, can you hear me now?
Perfect. Yes, sir.
There we go. Ms. Smith is actually correct. The 15,000 is grossly understated. It was a lot more than that, but due to the lack of evidence, it was not submitted. So I would only ask the court that there be no retroactive child support because, again, it was a lot higher, but lack of evidence. Most of the payments were made in person, but you can't really prove that. So I'm completely okay with whatever amount or the fact that she would like child support. I'm okay with that for whatever thing retroactive would at all be fair as well. So that wouldn't be a concern for anybody but
So, Mr. Hicks, are you paying his day?
when child support started.
Understood. Thank you, sir. Anything else?
That's it, Your Honor.
Okay. Ms. House, last word from the state?
Nothing further, Judge.
Okay, based on the testimony and evidence before this court, I am going to appoint both parents to be joint managing conservators. Under the temporary order, you both agreed to be joint managing conservators. Your son's last name with
Judge Gonzalez entered a final order appointing both parents as joint managing conservators, with Miss Smith designated as the parent with the exclusive right to determine Giovanni's primary residence. The court denied Miss Smith's request for address nondisclosure and imposed no geographic restriction permitting her relocation to San Antonio. Mr. Hicks received an expanded standard possession order accounting for the Austin to San Antonio travel. On child support, the court significantly deviated from the state's request. Rather than $887 monthly with $31,200 in retroactive support, Judge Gonzalez ordered $800 monthly current support and only $2,500 in retroactive support payable at $100 per month, reflecting her determination that the evidence did not support the higher income figures for the 2022-2024 period. All health insurance obligations from the temporary order continued unchanged. This proceeding illustrates a fundamental tension in family law: the aspiration for data-driven, consistent outcomes through guidelines and formulas versus the reality of incomplete records, self-represented parties, and judicial discretion. Texas's child support guidelines under Family Code Chapter 154 create a mathematical framework designed to reduce litigation and ensure adequacy. Yet their application depends entirely on evidentiary foundations that many parties, particularly those without counsel, cannot properly establish. Judge Gonzalez's reduction of the retroactive support claim from over $31,000 to $2,500 demonstrates how courts act as gatekeepers, refusing to rubber stamp calculations that exceed the proven evidence even when no opposing party effectively objects. The case also reveals how procedural mechanisms like de novo appeal rights, Texas Family Code Section 201.015, and motions for new trial provide safety valves for parties who discover post-judgment that critical evidence was unavailable or improperly excluded. Yet these remedies are time-bound and technical, often ill-suited to pro se litigants who may not understand their operation. The broader lesson concerns access to justice. Both parties here navigated complex financial and custodial issues without attorneys, achieving a resolution but potentially leaving value on the table. Ms. Smith in reduced support, Mr. Hicks in unverified payment credits. For viewers, this case underscores why family law practitioners emphasize documentation, why courts maintain flexibility to deviate from guidelines when evidence is thin, and why the best interest of the child standard ultimately requires human judgment that no formula can fully capture. If you're facing a family law matter, document everything: payments, communications, and agreements. The court can only work with evidence you present. Consider consulting with a family law attorney about your specific situation and explore whether your jurisdiction offers self-help resources or limited scope representation to help you present your most effective case.